meaning of the statute hinges also on that phrase being within the confines of the business establishment. But
anybody challenge his status as an employee?
no, and in my view, it was not challenged because in the statement of probable cause that the officers submitted to charge him, they identified him as the head of security, as he had self-reported, and as your honors know, that is a document, that's a sworn document, official record, and so in my view, there was no dispute that he was head of security at that club that night.
So the only issue is whether or not head of security meant that he could stay inside the building or whether he could go out into the parking lot.
In the adjacent parking lot of this club that was owned by Mr. Irving, who owns this club and the parking lot.
Now,
yes.
You said it adjacent, meaning that if you walked out of the club, you're at the parking lot.
Yes.
Okay.
Because we don't have any information that you have to cross the street, since one of the concerns by the legislature was the proliferation of guns in the public arena used for the commission of crimes. And I would submit to the court that in this context, when the legislature carved out these 7 exemptions, there was no particular exemption that received any higher authority or leverage than the others. The handgun permit itself, in our view, it's on par with the supervisory employee exemption. And the legislature found it in its wisdom to carve out this particular exemption for supervisory employees for these business establishments.
Well, counsel, what if, I know we don't have those facts here, but what if there was additional parking across the street? Would the exemption carry we'll change the facts for purposes of my hypothetical, would that have allowed your client to go to that parking lot and do what he did with display the gun and so on, or carry the gun at least?
Thank you, Your Honor. Mm-hmm. There's a bit of a conundrum there, because in your scenario, my client would then have had to cross the street, which would have placed him in the public sphere in order to get over there.
Mm-hmm. But I would submit to the court,
But I would submit to the court if he were found just on that side and the officers had not found him or saw him cross the street with the gun, then he would be in like circumstances as was here on the night in question. It is the being in the public sphere. This exception was carved out for business owners. It's their private property, both the building and, in this case, the adjacent parking lot. And
was the parking lot was the parking lot macadam or paved in some way?
We don't have that part in the record, Your Honor.
So we don't know whether it was improved at all.
Right.
You just mentioned the exception for the business owners, and I noticed there's a parallel exemption number 6 that for business owners, lessors, that includes real estate as well as within the confines, but the real estate language is not in the one for supervisory employees. What do you make of that?
And Your Judge McDonald, I was looking at that very exception this morning, and I was thinking, in looking at the absurd consequences type argument, you would have, for example, at this nightclub, Mr. Blue as a supervisory employee, and taking the Court of Special Appeals interpretation, Mr. Blue would have then been limited to the inside of the building, and if he's coming outside the doors, then he could not have the weapon. However, Mr. Irving, the owner of the business, it seemed that Mr. Irving himself could be in the parking lot with his weapon as being on his real property as exemption 6. And, you know, in the totality of these circumstances, if you look at what the legislature intended, is that the business owner would be employing somebody, supervisory employee, and in this context, it necessarily would be security. And so it is for the security who would be guarding.
the issue is the construction of it, though. Because if the legislature wanted the result that you're asserting, they could have said, within the confines or within the real estate that a person owns or leases, and in which the supervisory employee operated. But there's no language of real estate. That's what Judge McDonald's getting to. One does not always have security, in business establishments. We can both agree that. So, this might be a limited consequence. But we're talking about the construction, because they don't have any language of real estate owned and operated by the business. That language from 6 is not in 7.
Yes, and I see that, Your Honor.
Right.
However,
And so the absence of language that we know the legislature was familiar with, in another exception, what do we make of it, is my question, which I understood to be Judge McDonald's question also. What do you make of the fact that in one exception, they were giving a broad, that was pretty broad, right?
yes,
And not only was it broad, but they say, or within the confines of the person, of the business establishment that the person owns or leases. They're not saying, or within the real estate owned by a person in his business relationship or whatever. I mean, what do we do with that? Because
Aren't those two different concepts?
right.
I mean, is 6 and 7 necessarily inconsistent?
They're consistent by their terms. The question is between.
well,
no.
there's some similarities, just the differences being who is the person. One being the owner versus the supervisory employee in the sense of the business establishment.
But does within the confines of the establishment stand alone in both of those?
Mm-hmm.
Is there an inconsistency in that particular provision?
When you combine, as in 6, the real estate ownership portion with the within
Makes
the
it broader.
confines.
Right.
It makes it broader.
Right.
It makes it broader.
Yes.
Because it includes real estate. But
Yes.
does it change the definition of confines of the establishment?
I don't believe so.
Well, then they're not inconsistent, are they?
Right. Within the confines of the business establishment, it has to be,
Doesn't it mean the same thing in 6 as it does in 7?
it should, because it's saying the same, using the same words, Your Honor. But as we look at the words of the statute, we look at it in the meaning and we look at the meaning and the effect in light of the setting. And in this particular setting, especially since the legislature did not, allowing this exception for business establishment, the legislature did not carve out by saying only certain types of businesses would be afforded this particular exception. And so in looking at these words in the context of this setting, that's what we have to be focused on here, and the context of this setting being it's a strip club. It's not, some other type of establishment. This is a strip club, and it has this adjacent parking lot, and this is an adjacent parking lot and an area where there has been known, at least by the officers, also a lot of crimes that also happen, not just inside the club, but in the parking lot. And hence, it seemed that the legislature would want, as part of this exemption provided to business owners for protection of their businesses, that the protection be of the business, the building itself, the employees, the patrons, and property. And I would point out to the court that the legislature must have seen some wisdom also in affording this exemption to the supervisory employee, that such a person would have some level of training and experience to be able to bring to bear some discretion on how he or she would be using this handgun or having this handgun on his or her person.
I mean, is there any indication on the record in terms of the legislative history that all of these findings are there? I mean, because there's the correlative argument that could be made that the limitation to confines is made because they're trying to dissuade supervisory employees from being in hot pursuit from the confines of a business establishment, because the danger, I could proffer that it could have been found that the danger of allowing even trained supervisory employees into a public place, where into a parking lot or any adjacent, could create greater dangers for the community because of hot pursuit. So, I mean, what's in the record about this? What's in the legislative record other than you and I sort of surmising what a legislature could have done here? I mean, was there any findings, or was there anything in the record itself that supports what you're saying as to what the legislature could have done?
Well, I'm looking,
or could have thought?
In looking at one of the findings, I guess in the preamble, one of the findings that the legislature made, the purpose being that they found that there was an alarming increase in the use of handguns and crimes perpetrated by handguns. And therefore, the purpose was to stop the rise in the use of the handguns in the commission of crimes and to prevent the handguns being on the street and in the public domain.
That's exactly right. I mean, being on the street also includes outside of the confines of a business establishment. I mean, the problem that I have is that, what do we have that the is there anything, any testimony, any discussion that the legislature had about this? Is there anything about this anywhere?
I don't have anything beyond the purpose I just articulated, but I would submit to the court that Mr. Blue's position, duties, were consistent with the purpose, because he was there at Irving's for a lawful purpose, protecting the business. So the legislature's goal of eradicating or not having these guns out there for committing crimes, Mr. Blue was not committing crime, he was engaged in a lawful purpose. And in addition, he was not out there on the public streets or engaging anyone out there. He was within the confines of the business establishment, including the parking lot, and that's as far as he would go. And the record would show that prior to the officer's arrival on the scene, Mr. Blue had accosted a patron in a car in the parking lot. And that patron started to run. Mr. Blue and his subordinates were chasing him. But as soon as that man left Irving's parking lot, the chase ended, because Mr. Blue understood, and he stopped his subordinates. He understood the confines of the business establishment to be not beyond that parking lot, and he did not. They did not go beyond that. And so it seemed that just looking at the circumstances of this case, it fits in with what I believe was legislative intent, that it's not out there in the public sphere or domain, not likely to lead to any battlefield type situation. It's right there within the confines of the business establishment. The moment the person leaves that the confines of that business establishment. Mr. Blue no longer had any authority. He had to cease, couldn't pursue any further, and engage the police.
At the moment, Mr. Blue at the moment he was arrested or detained, it's not clear to me, what was he actually doing at that moment?
I'm sorry, at what moment, Your Honor?
At the moment he was arrested.
Okay. Well, at the moment he was arrested, when the officers arrived, they had arrived because the patron who was involved in illicit activity apparently made a call, and after he exited the parking lot, Mr. Blue himself called communications. So when the police came, they came because they were responding to an alleged call for shots being fired, which I believe the patron had made those calls. So when they came, they actually found out, inquired who had
Where
gone.
was he arrested? Where was he when he was arrested? Inside or outside?
I believe it was in the parking. It was in the parking lot because there are two sets of kinds of things that Mr. Blue did with the officers when they came.
It's one thing if he was on the parking lot with firing shots or the gun was flailing. I mean, how did he even know he had a gun? That's what I'm missing.
He told
Well, because the officers came to the scene and said they were responding to reports of shots being fired and inquired whether or not anyone had a gun. And he said he had a gun, identified himself as head of security.
Yeah.
And so one of the things he was doing with the officers in the parking lot was showing them the car where the illicit activity had taken place, and in addition, taking them to his car to obtain additional information to share with them.
Does the record show if he's wearing some type of uniform or something would identify him as security for this particular establishment?
Well, it does, the record does indicate that he was wearing a uniform, but the whatever emblems that he had on the uniform was not an emblem saying Irvin Security. But there was no doubt to the officers that he was security there, because after they asked if he had a gun, he gave it to them. They looked at it and examined it to see if it had been fired, then they gave it back to him.
Okay.
And so I see that my...
No, you've got a minute.
that was a minute, yes.
Counsel,
yes.
to take us back a few moments in the argument, back to construction of subsection 7 in comparison with subsection 6. How would you define, or what do you suppose the legislature meant when it used the phrase real estate? Something different from confines, I suppose. In subsection 6 now, I'm taking us back to Judge McDonald's initial question on the subject.
I would interpret real estate to be improved and unimproved.
Okay.
So
And confines being a subset of...
I'm sorry, that would be land and or building, and in this case, that would be the parking lot and or the building.
Okay. So confines is essentially the same as real estate in the building, in the context of a business establishment?
In this particular circumstance, but it could be different in other circumstances.
Okay. All right.
Thank you.
Thank you, ma'am. Ms. Johnson?
Why don't we pick up right there? The comparison of subsection 6 and 7 has occupied quite a bit of time this morning. Would you agree that under 6, the owner of this business was authorized to carry a handgun without a permit, and he could go out in his parking lot because that's part of his owned or leased premises?
Correct, yes.
But his chief of security would have to, if there was a dispute in the parking lot or something that exited the building and was going on in the parking lot, would have had to say, hey, owner, you got to go deal with this. I can't go out there with my handgun.
That is correct.
Now, is that a commonsensical interpretation of 6 and 7?
It is, because...
Why would you hire a chief of security who could only do something within the 4 walls, but warfare could occur in the parking lot and the owner would have to go do it?
Well, the owner does not have to go do it. As the record showed in this case, Prince George's County Police were familiar with Irving's nightclub. The record also reflected that when they were called, they responded. The owner does not have to do that. Mr. Blue, if the owner,
choice. Does he have the choice?
He does. He has a choice, and he could. Mr. Blue could find out that there is some person could come inside reporting that there is some activity in the parking lot. Mr. Blue could immediately call 911. Prince George's County Police would respond and take care of the situation in the parking lot. If Mr. Irving wanted Mr. Blue to patrol the parking lot and as part of his duties, then Mr. Blue should have obtained a permit so that he wouldn't have to worry about leaving the gun inside. He could take care of his duties, but he would have a permit to do so. He wouldn't have to worry about whether or not he was inside or outside of the building. I believe that the court focused on exactly what I would ask the court to focus on, because the legislature made clear when they made the revision in 2002. Before then, those 6 and 7 were combined. And after 2002, they separated it. And when they separated it, I believe they made it clear that the owner is the only one that has that authority to go outside and protect his property on his real estate. That was not included in 7.
If that's what that meant, why didn't the statute just say the parking lot?
Excuse me?
If that's what it meant, why didn't the statute just say parking lot? If the confines of the business means only the walls of the business, whatever the business happens to be, then all you need to say is the owner can go outside to the parking lot, not to real estate, because there is nothing inconsistent with saying, except to make it broader, that there is real estate access for the owner and the business establishment. That doesn't define the confines of the business establishment. Do you follow me?
Yes, I think I do.
Okay.
I think the reason why they didn't use parking lot and just included real estate is because they were looking not only as in businesses like Mr. Irving's.
Mm-hmm.
They're looking at other businesses that may not have their parking lot is not the entire property. So they wanted to be inclusive of everything that owner has ownership interest in number 6.
So for example, a commercial creamery on a dairy farm.
Exactly.
Where maybe ice cream is being sold or some such thing as that. There might be a parking lot, there's the pastures where the cows roam, and there's the milking shed and all the rest.
Exactly, and that may encompass acres.
Right, but then why didn't it say, if that's the case, why didn't it just say business real estate as opposed to the confines of the business and real estate?
Well, I think
because what I'm getting at is, to say real estate merely adds another category, but it is not inconsistent with confines of the business establishment if one defines that to include something other than the walls of a building.
Right. I think that when it comes to number 7, or number 6, when they said on real estate or within the confines of a business establishment, they were contemplating lessees who may just have an interest in what is within those 4 walls and has no interest in what is in the parking lot or the surrounding area.
Let me try it another way.
Okay, I'm sorry. Maybe I'm misunderstanding.
Let me try another way. Suppose I open a dairy store. And, well, one of those things, the soft ice cream. Mm-hmm. And I open it. The only way I'm going to make any money is if I have parking, right?
Correct.
And so I have the parking lot. It's a little strip thing, like as you drive down Route 1, you see it. You pull in, and now, what's the limits of my business? Just a little shed that I use to give you the ice cream, or is it also the parking?
Well, I would say that, I guess to me, it depends. One, it depends on, if you're talking about if you're on a strip mall, you are sharing that parking lot with other business owners.
I'm the only one there. I'm the only one there.
If you're the only one there.
I've got one strip there. That's it. And it's clear that when you pull into that thing, you're going up to my shed to get my soft ice cream, and then you get back in your car and you go on about your business. Is the extent of my business establishment just the shed from which I dispense the soft ice cream, or does it include the parking?
I would say that it includes just with using your terms, your shed. That is what you are, that's what you have ownership interest in, is your shed.
You have to answer it that way, but does it really make sense?
Yeah.
When you think about either Judge Bell's example or a bar. When people leave bars, they're often intoxicated. When fights break out in the parking lots of bars, that is something that the bar owner clearly has to be concerned about, isn't it?
Yes, and that's why they call the police. Or that's why, but if they hire security who they want to patrol that parking lot, then that person needs to have a permit. No one's saying that Mr. Blue could not do his job outside in the parking lot. All we are saying is that if he is going to take his handgun out into the parking lot, then he needs to have a permit.
When you compare the sections 6 and 7, do you have the text in front of you?
Yes.
It seems to me that what is the appropriate comparison is to take the language of 6 that comes after the word or, which is just within the confines of a business establishment that the person owns releases, and compare that to 7, two little i's.
Yes.
Whereas it makes little sense to compare the language in 6 that comes before the or. Do you agree with that?
Yeah, I mean, that...
You do?
I mean, within the confines of the business establishment in 6 is the same as within the confines of the business establishment in 7. I agree with that. I think that what the difference between the 6 and the 7, though, is that in 6, they are saying that the owner or leasing has more rights because of the phrase "on real estate." But I think that when it comes to number 7,
but why do you have or within? Why do you have the or and what follows in 6? Under your interpretation, why would you need that additional language?
I think that it depends on the business that you have, and I believe it depends on the location. As we were speaking earlier about a business that is encompasses acreage, then within the confines of the business, the establishment might be one thing, but the business itself, and depending on what type of business, like we were saying, dairy farms, could encompass acres. And so I think that is what the intent was in 6, is to allow the owner who is on their property that they own or lease to be able to defend that property.
Let me ask you a question. Is giving the owner the right to have a gun in real estate that he or she owns any different than the state of the law without that statute? I mean, I have that right now, don't I?
Yes.
So what does it add?
In your parking lot?
Not in my parking lot. Not in my parking lot. I don't see this as being limited to the parking lot. I see it as being in addition to the confines of the building. As Judge Atkins has pointed out, that those are two different concepts.
Yes.
So if the owner owns a house,
Yes.
the owner can have his gun in his house
Yes.
because it's his real estate.
Yes.
If the owner has a summer house, he can have his gun there. But he also is able to have his gun on his business premises,
Correct.
within the confines of his business premises, whatever they may be and however they may be defined. But that's separate from the real estate. Because otherwise it would read business real estate as opposed to simply saying real estate.
Right, and I think also it was contemplated.
You agree with me?
I'm with you so far. I believe that, and also I want to point out is that,
Good.
let's say that there's a piece of land, an unimproved piece of land that
Yes.
this person owns. There is no building or shed on that land.
Sure.
Then that's where number 6 would come in. That owner of that real estate could be there with his handgun.
Yeah, but it doesn't have to be related to the business.
Right,
That's my whole point. I mean, it could be 6 miles away.
right. If he owns
It
a
could
piece
be-
of that
if he
property.
owns it anywhere in the state, he
Right.
has that right. That's what 6 gives him, right?
Yes,
But it also gives him, because it's or,
yes,
it also gives him the right to have it on his business
correct,
within the confines.
yes.
Now, that real estate doesn't relate to that parking lot.
Okay,
Well, you know, well, I shouldn't say it does not. It may not relate to that parking lot, because the owner clearly, if the definition was that the confines is limited to the walls of the building, then the real estate would cover the owner. That's the position that you're taking. But I don't think it adds anything to the second part of that particular provision, I mean, or the second part of 6. They're two separate things.
yes. I mean, I see that you're saying that on the real estate is separate and apart from within the confines of the business establishment.
It does not necessarily have to be related to the business itself. That's right.
Right.
So that means that it's not inconsistent with 7.
that
6 is not inconsistent with 7.
right. It's not.
Now, the real issue is how do you define
Right.
within the confines of the business establishment?
Exactly, and I think when the Court of Special Appeals took the correct approach, they looked at the plain, ordinary meaning of those words within the confines of business establishment. Within meaning something inside, confined meaning something that is enclosed, business establishment meaning something that encompasses a business with furnishings and staff. Taking those words together in the context of the entire statute, then it comes to the logical conclusion that we're talking within a business, the building itself.
Do you happen to know whether the liquor laws use any terminology that could be analogous to that here, such as defining whether you can serve the beverages within the building and not within the parking lot, or do they use the term business establishment or business?
And add to that, whether it does put certain responsibilities on the owner of the establishment to police the surrounding area, including the parking lot.
I at this time, cannot answer that question directly, Your Honor. I do not know exactly what the liquor laws, especially with dealing with Prince George's County, are. But I can say that I would say that in going to looking at what the Court of Special Appeals looked at, I would say that to adopt Mr. Blue's broad interpretation of this statute, this exception to the establishment, and let's please focus that this is an exception to the general rule here. And the general rule is that if you're going to wear carry or transport a handgun, you have to have a permit. And a broad interpretation of this exception would frustrate that purpose. And I think that, and this court also addressed this in a similar circumstance in State versus Williams not too long ago, where a person was walking down the street and an officer saw him putting his hand in a backpack, and then he saw him put something behind a bush. That officer investigated and come to find out it was a handgun. The person bought it legally, but he did not have a permit to carry it. And this court addressed exception number 6 and said that, if he was home or on his property, it would have been fine, but he is not on his home or on his property, and you did not want them to really, as what the Court of Special Appeals said, have a situation where you have, a shootout on the streets or on the streets. And they were talking also about, in the situation with Mr. Blue, he went outside to investigate some illicit activities in a car. He was lucky that the person in the vehicle did not have a handgun. He had absolutely no clue what he was confronting at that time. And that person, luckily, did not see Mr. Blue as a serious threat, or if he did have a handgun, and start a car. And that's exactly what we do not want. And also, what could have led to another consequence is, let's say that did happen. Police are called because there's a shooting. They come onto the scene. Mr. Blue is in a blue type of uniform with no insignia saying, head of security, or anything identifying himself, visibly as security. He's dressed in a type of outfit that you may think is security, but you do not know. We do not want our police officers coming onto the scene and not knowing who is a victim and who is the perpetrator here. And it can cause a lot of confusion, as it was when the police did show up. Mr. Irving was, had his handgun on his person. They saw it. That's what prompted them to ask, do you have a permit?
Well, I think you made your point about what the county's legitimate motives are in wanting to have the statute interpreted this way. But I'm still concerned what a ordinary citizen of average intelligence who didn't go to law school would understand what subsection 7 means. And to extend Judge Barbera's hypothetical to both another hypothetical and a real situation. Let's go with the real first. Where could the head of security for Six Flags carry a handgun without a permit?
Good point.
Prince George's County, known facility.
Yeah.
Most of it highly developed, but in an open-air situation. Big parking lot. Lots of open space, too.
That does present a good question.
If it's a good question for lawyers and judges, it's a hell of a question for lay people.
But exactly, and I think that the question, the reason why I say it's so good and everything is because, as we all know, ignorance of the law is no defense, and we all know that. I think that in the most prudent position for a person or people who are working as security for Six Flags, so they don't have to worry about whether or not I fit within this exception or that exception, is to comply with the general rule, which is have a permit. Then he doesn't have to worry about whether or not I'm inside a small building and this is the confines, and if I go to walk across the Six Flags to another building, am I in violation of the statute? If he has a permit,
right, I get the thrust of where you're going with that. All right, how about a Christmas tree farm?
I would say
I'm the owner of a Christmas tree farm.
If you're the owner of a Christmas tree
I want to
farm,
hire somebody to watch my trees. until it's Christmas.
Same answer.
Hire someone who has a permit.
Fine. I don't want to do that. I want to hire somebody who
it's
can carry a permit, who can carry without a permit on my property.
Because it's cheaper.
Well,
save
there's,
Yeah. Maybe the person I want to hire as head of security has a criminal record.
well, then,
That means they're a better shot.
well, there's always alternatives, and one alternative is, and which has been employed with the Prince George's County and other county governments, is that a lot of our officers do work off-duty employment.
Fine, you're offering alternatives. I'm saying, I hear you, but I don't want to do that. Because off-duty police are expensive.
What are the confines of that Christmas tree farm? What are the confines of it? It's 10 acres.
It's 10 acres. I would say whatever
It has a
building
parking
is
lot
that,
in the
whatever
middle.
building you
Oh, the
have.
building. Oh,
No
okay.
building.
No,
No
It's a
building?
Christmas tree farm. You come, you give me your money, you go cut your tree down.
But they do have a place to park.
They have a parking lot, yeah.
Well, I think in that situation, you can't do it without having, without,
So there has to be the boundaries of the property are not a confines for purposes of the statute.
not confined within the business establishment, no.
Okay.
So you have to have an improved structure, a man-made structure.
That's what was contemplated in number 7.
All right.
Thank you, ma'am.
Thank you.
Ms. Henry?
Thank you, Your Honors. I just want to point out that there's no general rule to have a permit. The general rule is to not have the guns. The permit is exception number 2, just like the supervisory employee exemption is number 7.
Well, I had a question.
Yes, Your
When this incident happened, he identified himself, or he had an identification as Special Agent for United States Fugitive Enforcement. Did anything come out about what that was about?
That was that was one of the different papers he did show. That was a private security company that he owned, but through it he was providing this security, and he was hired as head of security at Irving's.
So that's his security company?
Yes.
Okay.
Yes. Approved by the state of Maryland, yes, with that name. The bottom line, Your Honor, as the interchange has shown, is the heart of the discussion here and the heart of the focus for this court is the meaning to ascribe to within the confines of the business establishment. And I believe the interchange has shown that within the confines of the business establishment is going to be specific, or you look at the type of business, just like with the Christmas tree farmer, within the confines of that person's business establishment, it's going to be that farm and the boundaries of it, and no structure is required. Similar thing for Judge Bell, your ice cream or the soft cream person who has just a little shed but has a parking lot. Yes, in that context, it would include the parking lot because that would be within the confines of the business establishment, and we submit that's precisely the meaning and definition that should be ascribed to within the confines.
Do you know whether the alcohol laws in Prince George's County put certain responsibilities on the owner of the license outside the premises, the parking lot, for example?
Your Honor, I have to apologize to the court, but I did not look at that particular issue.
Do you know what the, quote, licensed premises, end quote, are for
Right.
purposes of the alcoholic
That's-
beverage license
that's
that
the
your
point, yeah.
client's facility has?
That's right, yeah. That's the better question.
That's the statutory term,
That's the better
licensed
question.
premises.
That's right.
And it may or may not include the parking lot even if they have, even if the Board of License Commissioners holds them responsible for security of the parking lot,
That's the better question.
what they're actually regulating is the licensed premises.
Premises, right, yeah.
Okay. And, Your Honor, also, because that wasn't even an issue that we were looking at the trial level, and so unfortunately, I can't answer that question. But for purposes of the supervisory employee exemption, just like all the other exemption, it's accorded the same weight as all the other 6 exemptions, and in this circumstance, all we're looking at is the definition of within the confines of the business establishment, because the statute itself did not provide a definition, and in this circumstance, none was needed, because we give a common sense approach to this definition. And for this case, Mr. Blue was operating within the confines of the business establishment at Irving's, and therefore, I respectfully ask that you overturn the Court of Special Appeals decision, because that is far too narrow, not within the purpose, scope, and intent of the legislature, and reinstate the jury verdict. Thank you so very much.
Thank you all. 95 and 101.